Arbitration, Nepal International ADR Center, NIAC, and Gyanpunja School of Leadership has jointly organized professional arbitration training for our participant assemblies from different professional background. Most of the training session, including practical session, are conducting at physical presence, and some sessions are planned to be conducted online with esteemed scholars from domestic and international jurisdiction. Today, we have ADR professionals from Pakistan, Mian Sheraz Javaid, popularly known as our friend Mr. Sheraz. He is working as a barrister in London, also working as an arbitrator, adjudicator, CDR accredited mediator, civil engineer, dispute board member, ADR ambassador in London and Pakistan. Now he is leading Pakistan branch of Chartered Institute of Arbitrators. As an arbitrator, he is working in Middle East, wide range of Africa and Asia Pacific region. He is also working with us in Nepal to develop our arbitration system. He was one of our esteemed speakers in the international conference organized by Nepal International ADR Center, NIAC, in December 12 to 15, 2024. He also came and spoke as a chair of the national conference organized by NEPCA. Now, we are so happy that he is leading us towards Chartered Institute of Arbitrators with a Nepal branch in Nepal. It may take long time if I continue to say about him. With his brief notes, I would like to invite you all and would like to invite Mr. Sheraz to lead the topic on contribution of institution in arbitration and some model arbitration institutions like NIAC, APCAM, finally, and popularly Chartered Institute of Arbitrators. Now, Mr. Sheraz, you are most welcome, and you are here, and we are so eager to welcome you, sir. Please lead the session.
Thank you so very much, Mr. Matrika, and namaste, everyone. I'm humbled. Thank you so very much for your kind words.
Namaste.
I think it's just the God Almighty who should be praised, not us. And I'm feeling honored to address this august audience and to share my views about how the arbitration institutions, ADR centers in general, they have played their role, especially in last 15, 20 years. If we see the world in 1990s, starting from the entire Middle East region to this part of South Asia, you will see there were like only 3 arbitration centers up until 2000, 1999 or 2000. As we speak today, there are more than 51 centers, established centers, and Singapore, being part of this Asian belt, they have been able to snatch the title of most favorite seat of arbitration of the world from London, who had the honor of having the title of the most favorite seat of arbitration of the world for more than 100 years. To start with, I would like to give you an overview of the type of arbitration systems. Technically, the world is now moving from ad hoc arbitration to institutional arbitration. what is the difference between ad hoc and institutional arbitration? In ad hoc arbitration, we appoint an arbitrator either by consent or through the court or through the appointing body. If it is one arbitrator, the sole arbitrator, then both the parties have to agree on the name of the arbitrator. But if it is a three-member panel, then each party has the right to nominate one member of the tribunal, whom we call as the party nominated arbitrator. And then these two arbitrators then eventually have to consent and agree on the third arbitrator, who can be titled as the president of the tribunal, the chair of the tribunal, or the presiding member of the tribunal. And this is how the constitution of the arbitration tribunal takes place. But in ad hoc arbitration, it is just the arbitrator or the tribunal who is responsible for the um, entire arbitration proceedings. The whole process is to be undertaken by the arbitrator. And let me take the liberty of calling it a sole arbitrator. So it for ad hoc arbitration, the arbitrator, your arbitration proceeding is as good as your arbitrator is, which means the arbitrator is not going to get any support whatsoever from any institute, and he has to use his own acumen, his own experience in starting the arbitration proceedings up until the issuance of the award. And in contrast to this, for last 20 years, a new trend has been emerged in the world, which was what we call is the institutional arbitration or administered arbitration. What do we mean by institutional arbitration? Like in this regard, an institute, for example, Nepal Institute of ADR, Nepal International Arbitration Center, NIAC, or Nepal International ADR Center, they set up an institute, which they are, and they are dealing with the international arbitration element, and they will be administering the whole arbitration proceeding. The arbitrator will be the same, who will be working as ad hoc arbitrators. And at the same time, they will also be associated with arbitration centers. But in institutional arbitration, the arbitration centers, they actually supervise the whole process, and they remain with the arbitration, with the arbitral tribunal or the sole arbitrator, whatever the case may be. And in that regard, it is a big support. For example, if it is a sole arbitrator and ad hoc, there is nobody who is going to ping him and ask him to, to take those procedural hearings, procedural order 1, procedural order 2, procedural order 3. What about the exchange of evidence, disclosure, discovery? And sometimes they do waste time because they don't have that support. But in administered arbitration, institutional arbitration, we've got a case manager who has the duty to constantly vouch on the arbitration proceedings constantly with them. And that is big support in terms that somebody is looking after me, somebody is chasing me, somebody is pressurizing me so that I can be on time throughout. And instead of taking more than a year, I am or I should be able to produce my arbitration award in that 12 months of bracket. And this is just one element to it. Few arbitration centers, they have introduced the concept of scrutiny of award. So what does that mean, scrutiny of award? So, once you you decide that you want to get your dispute settled through an arbitrator, which is an alternative to the court litigation system. And these arbitrators are not for free, they charge money. In domestic arbitration, they don't charge a lot of money, but in international arbitration, the amounts are really hefty. You will be amazed to hear that in a normal ICC arbitration, you might need to spend around $1.2 million to touch and go the ICC arbitration. It's like two and a half, $300,000 has to be paid to the arbitration center, and then $500,000 on one side of the of the parties in terms of legal cost, $500,000 on the other side, the legal costs. And after spending $1.2 million, it also takes between 12 months to 18 months for an award to be rendered or to be published. But after 18 months and after spending $1.2 million, if my award, probably the award is going to be challenged because one party will be a winner, one party will be a loser. So the loser is going to, is going to file an application to set aside the award at the seat. And when they do that, and if your award is not what we call as the enforceable award, it's not up to those standards, or it is unable to went past the testing of the award by the court, so your award will be set aside. And all that money, $1.2 million, $1.3 million, along with 18 months, is all gone in waste. Nobody wants that, which is why the institutional arbitration centers become more popular. Why? Because in ad hoc arbitration, the chances of mistakes are far more as compared to the institutional arbitration, where they are looking after that arbitration proceedings. And at the end of the proceedings, when you are about to publish the award, the institute is going to scrutinize. Scrutiny means they are going to check and vet the award, and they will mention if there are any discrepancies, shortcomings in that award. So they will let that arbitral tribunal know about those shortcomings, and then the tribunal then redo that. And the idea is the award once issued should not fail the testification process by the court. What are the criteria in terms of institutional? It is administered, for example, managed by a recognized arbitral institution. So there is a war going on in the world now. And a lot of people ask me that we have to become fair. The Englishmen are not fair. They just took all the arbitrations to their world, to their homeland, which is true. But we need to understand the element of fairness is not the problem of the world anymore. The corruption, the element of corruption by the tribunal is not a problem anymore in the world. And I'm not talking about the entire world, but if you talk about LCIA, London Court of International Arbitration, Singapore International Arbitration Center, Hong Kong International Arbitration Center, so these all arbitration centers, you don't find that problem of element of fairness, which means that they are not going to take part of one of the parties. If they are going to do that, you see, in England, 75% of the cases which are pending before the British High Court, they are not British cases. They are cases from around the world. People have took their disputes to the British High Court, and they have given them the jurisdiction to please adjudicate on the matter. And it's not because of any force. It's because they are fair. They produce a very neutral award. And then they were the only ones up until 2005. And then all of a sudden, Singapore International Arbitration Center, they also started to get their credibility as one of the most finest arbitration centers with no problem with the fairness at all. So LCIA is fair. Singapore International Arbitration Center is also fair. But then when there is a competition in the market, then you have to give something additional to your market. So Singapore was a bit less expensive than England. Both of them are fair. Both of them are giving the best jurisprudence. So automatically the world started to travel towards Singapore International Arbitration Center, because it's not about being fair, it's about being cheap now. And then Hong Kong also realized that. Australian Arbitration Center realized that. Even now, the Dubai International Arbitration Center, they've also realized. You will be amazed to know that the amount of money that is being involved is like, the figures are staggering. England is making 65 billion pounds by this export of dispute resolution, that people are coming down to their arbitration centers, they are resolving their disputes, and the money they are making is 65 billion US dollars. My apologies, it's not pounds. And then Singapore International Arbitration Center is making, in 2023, they made 80 billion US dollars just for dispute resolution export. And now, keeping that in view, Dubai International Arbitration Center, the emperor, the ruler of Dubai, he appointed his own very niece, the daughter of his brother, as the executive director of Dubai International Arbitration Center, because now they want to snatch some of the business, maybe 15, 20, 30 billion pounds, the $30 billion, to come down to Dubai. Fairness is not a problem. Now we are talking about who is more cheap and who is more time effective. Because the Englishmen, they take at least 4 weeks to respond, but the Singaporeans, they take 12 days. Dubai is saying we are going to take 10 days. Yes, all right. You are fair. You're also fair. You're also fair. You are cheap. No, sir, Singapore is not cheap anymore. So Qatar is coming in, Bahrain is coming in, and we are also hoping to see Nepal to come in as a seat of arbitration. Fairness should not be a problem. But then in institutional arbitration, this whole tug of war is being is about fairness, is about credibility, which is why they have got very highly sophisticated case managers being deputed by the arbitration centers who look after the entire arbitral process. Versus ad hoc arbitration, there's no supervision. If the arbitrator is good, if arbitrator understands the whole system, he will be able to conduct more smoothly. But if the arbitrator does not have that requisite, skill set or the facility of having tribunal secretaries and stuff, it will be difficult. Rules and procedures, um, both use almost the same unset roll rules. Rules are not too different. If you are not a model law compliant country, then you might struggle with the rules. But otherwise, every arbitration tribunal, they use certain rules, and UNCITRAL model rules are the most used rules around the world. But then using an arbitration center also comes up with the advantages, like if you want to challenge the jurisdiction of the arbitrator, instead of going to the court, which is more expensive, which is time expensive as well, you can challenge before the arbitration center. You can also get the award corrected from the arbitration center. So there are few elements, few additional benefits that you also get from the institute, which you don't get in ad hoc, because anything that goes wrong in ad hoc, you have to go to the court because there is no appointing authority or an institute involved. And then the arbitrator appointment, parties, they have to mutually decide. If they are unable to decide, then they have to go to the court. And the problem is, in countries like South Asian countries like us, we don't want to go to the court. It takes a lot of time to go to the court. Something that can be settled within the institute in 3 days, this is going to take at least 5 to 6 months. In a country like Pakistan, I'm sure, I don't want to comment of how long does it take in Nepal, but in India, Bangladesh, Sri Lanka, it's the same time. And then case management and administrative support. We just discussed, there is no case management and administrative support. So Queen Mary University in London, they did a survey that 75 per 76% of arbitration, the parties prefer institutional arbitration now, for the obvious reasons that there is somebody who's looking after the entire process. They are going to check the award. The award should pass the testing process, and it is only possible when some institute with all that institutional memory is supporting in getting that institutional that arbitration award. And at the same time, ad hoc arbitration is 1/4 cheaper than the institutional arbitration, because it's just one arbitrator who is charging maybe 5 lakh rupiah. But now if you talk about the institute is also charging 15 lakh rupiah on top of 5 lakh rupiah. So there is a cost of 20 lakh rupiah. But then if you're spending that 20 lakhs, that 20 lakhs is actually giving you an award which will pass the testing of the court. It will not be set aside. And this is what the parties want. After spending X amount of money and after spending 1.5 years, award is just nothing. They want to have their money back. That award is going to act as a tool, an intermediary tool, so that they can get their money. And if their tool gets broken from the court, there's no point. So these are the stats that Singapore Arbitration Center has got 1,000 cases just in 2022. ICC is one of the most popularly used arbitration center. They got 850 cases. So when you talk about regional and international arbitration institutes, I'm really impressed with the idea that, and why I contacted Nepal International Arbitration Center at the first place, that they have got they have become the torchbearer to open up the International Arbitration Center. And so domestic and international, there are two different ball games. In domestic, it's one law, the same law of contract, same law of arbitration, same rules. But in international, the law of contract can be from Pakistan. The law of the seat can be different. It can be Nepal. And when we talk about regional, so these are regional as well as they are also international in terms of SIAC, HKIAC, APCAM. APCAM is like, a conglomerate of 7, 8 different arbitration centers. So which is, and then they have given a name to them, that instead of having one, we can have a conglomerate of 8 arbitration centers. And then international arbitration centers, ICC, LCIA, ICSID. ICSID is the famous investment arbitration center by the World Bank. So what contributions have they made so far? So it's the development of standardized rules and procedural certainty. Of course, the procedural certainty is the key. It is only because of these institutes that we can now hear that they have got expedited rules. Expedited rules? What does that mean, sir? Expedited rules. We will issue an award within 6 months. That's fine. It's really difficult when you have to give 28 days to one party to submit the defense, 28 days to the other party to reply to the defense, and then another 28 days for them to exchange their evidence for discovery, and then another 28 days for inspection and all that. You are not left with any time. So if you are going to take 4 months for to reach to the hearing, I'd sir need at least 60 days to write down the award. But these arbitration centers have now given this new, because they have all opened up their shops. Everybody wants to have more customers, and more customers can only come to you only when you have the best of the things which the market wants. And the market wants things. So it's not test cricket anymore. It's not even one day. It's not even T20. It's the time of T10 now, which is why the efficiency in time is also coming in. So these leading institutes like LCIA, Singapore International Arbitration Center, ICC, HKIC, they have actually evolved over 20 years, and they have played a very vital role in bringing the idea that it's not just the Goras, the people from England or the British one, the Englishmen who can be transparent. We are more transparent than you. It's not just you who is for the Englishmen who are considered to be the mother of all laws, that they're the best in interpretation and judicial precedents and all that. The judges of Singapore have developed even better jurisprudence in arbitration in last 15 years than the Englishmen. And then the UNCITRAL model law, they have served the foundation, the whole idea going on for last 70, 80 years, that we need to have one harmonized system for international arbitration. If parties are coming down from US to invest in Nepal, and if a Nepali arbitrator is going to look upon the matter, so the award rendered by the Nepali arbitrator should be of the standard that's the standard which the US arbitrator is adhering to, or the English arbitrator is adhering to, or the French arbitrator, or the Singaporean arbitrator, or the Hong Kong arbitrator. Otherwise, why should we give equal importance to your award if that is not of the same quality? So we have to produce things of the same harmonious level, which is why the idea of model law developed by the United Nations, and it was the third thing we call it the three pillars of international arbitration, starting from the New York Convention, which we signed in 1958, when all these nations, they sat down together and they decided that we need to have some harmonized system. And if we have a harmonized system, the investors from these countries will feel more safe and more prone to to come and invest in your country, because your arbitration award is almost equivalent to the arbitration award of my country. So I will be safe. And which is why foreign direct investment is directly related to your arbitration setups, your ADR setups. So from New York Convention, they came up. So they said, all right, if we have to bring award of the same level, then we need to have same arbitration rules. So all the arbitrators will use these rules, whether they are sitting in New York, in London, in Pakistan, in Nepal, they are going to use the same rules, and it is very fair and something which should be complemented. That's fine. The same rules have been given, so we call it UNCITRAL model arbitration rules. But then another problem came in with the process of evolution, that the arbitral tribunals are using the same rules, but the courts are different. If the tribunal is sitting in Nepal, the law is the Nepal Arbitration Act 1999. If the tribunal is sitting in Pakistan, it's Arbitration Act, and you will be amazed to know it's Arbitration Act 1940. And if the tribunal is sitting in India, it's the Arbitration Act 1996. It's model law compliant. I'm not sure if yours is model law compliant. Pakistan is during the British Raj, it's not model law compliant. So how can the courts give the same supervisory role for the arbitration tribunal? So they came up with the model law, that same model law in each country. But the problem with model law is you have to get it enacted by the National Assembly or by the Senate or whatever your system is. There are 172 countries right now who have signed up for the New York Convention. And then institutional rules, they actually minimize judicial interventions for those small things that you have to run towards the court. You can get that thing settled before the tribunal. Um, and before I go on to this, the second one, with all due apology, I was fasting. It's Ramzan. If I can have 3-4 minutes of just to open up my fast, and I'll be back
Please,
here.
please, please do
Sir,
so. Take
sir,
it
thank
easy.
you.
Please do so. We pray to break your fast.
Example of expedite. I was just giving you the example of expedited rules, for example, that that is within 6 months the award will be issued by the tribunal. And then what is administrative and case management support? So the data by Singapore International Arbitration Center reveals that 90% of cases benefit from institutional oversight. Of course, no matter how trained and qualified I am, if I've got a support, an institutional support with that institutional memory, it is actually something which is really big for us in terms of they are going to help me settle the matter throughout the time. They are going to help me with the timelines. They keep reminding me the case management support, the administrative support. They are also going to help me in terms of contacting the parties, of when the parties needs to be contacted. They are going to give them the prompts if they have to submit their defense, they have to submit their reply to the defense. They are also prompting the parties, and which is actually a big thing. That is, in courts, it's just your responsibility, but from their arbitral tribunal center, they're also coming down to you, asking you to be in time. So they have provided structured mechanisms, consolidated proceedings, and they are actually now reducing time. I am not too sure about cost. I think the cost is getting higher and higher. Arbitration has become a really lucrative business. So the LCIA report 23 highlighted that institutional arbitration reduces procedural inefficiencies by 35% compared to ad hoc arbitration. And I hope you can now join the strings in terms of what I have just briefed about the benefits of institutional arbitration. and then the roster of highly qualified and vetted arbitrators. So these arbitration centers, they actually promote themselves on the basis of the members, the tribunal members that they have. But in ad hoc, where do you go? How do you get the ad hoc arbitration appointments? Um, do we have a roster somewhere, just like the Chartered Institute provides, where you can go and find out the roster from people I can choose? If I want to have a complex engineering dispute, I need to see the profiles. Is there a place where I can go and find those profiles? And then the diversity in terms of what we call is people from different. You'll be finding doctors as arbitrators, um, tax consultants as arbitrators, engineers, lawyers, architects. So a diverse range of people are part of that arbitration center. And you can find people wherever you want from them. And then enhanced recognition and enforceability of award in terms of scrutiny, what we call, and then the procedural safeguards that they provide in reducing risk of annulment of non-enforcement in national courts. There are a number of elements that are going on, and in that regard, the testing of your award is the most important and most basic thing, and which is why all these setups of new arbitration centers we can see now. So, in terms of what Siab is, yes, Mr. Pahari, Dinesh, I can see you have raised your hand. You want to say something now?
I think it may be by mistake. Please go ahead.
Right. So, in the Chartered Institute of Arbitrators,
Excuse me, yes, it wasn't by mistake.
Oh, yes,
please
please.
go ahead.
Yeah, I couldn't unmute it, so I was taking time to do that. Um, um, I just have a bit question about, you were talking earlier about the challenges about of the arbitration process, where you talked about the involvement of too many nations, and then how the court, the governing law and everything. So could you please highlight a little bit more on that? I was just stuck on that one.
I couldn't get your question exactly. Like when I was giving you the brief about what a pure international arbitration is that what you're referring to?
You were talking about challenges of when the nations are involved, and you were talking about, since their court and the governing law, and challenge, pretty much the challenges about this process.
So the challenge was that topic is about harmonizing international arbitration system. And so what does that mean? What do we have to harmonize? So the idea is that if the investors from Pakistan, they are coming down to Nepal, is it a safe place? Yes, it is safe in terms of the environment. It is one of the best tourist spots. What about the ADR setup? Do I get an award like the way I get in Pakistan? No, sir, you might get a better award as compared to Pakistan. But if an investor coming down from England is asking the same question, probably then there's a big question mark. Then you'll say, no, sir, we don't produce an award within 12 months. And then there's one appeal, second appeal, third appeal. We have got a system of our own. All right. So you have got a distinct system, which system is different than the system in England. Then how will this cross-border trade or investment will take place? And then it's just the example of two countries. What about 15 countries or the entire SAARC countries sitting down together? So Bhutan, Bangladesh, India, Pakistan, Nepal, they want to raise the investment between the cross-border between the SAARC countries. But for that, we need to have a singular unified ADR system. If a dispute comes in, at least for the SAARC investors, we need to have something which across the board is uniform. And if it is not uniform, if out of 8 countries, 6 countries have got that harmonious system, the investor will feel more safe to go in these 6 countries rather than the other 2. So that is the tipping point. And for this, after that World War I, when the entire Europe was destroyed, these European countries, they were sitting down together and they were trying to find out a solution. And that if we are going to invest among each other within the European Union, then what will be whether our agreement, which is the agreement between the investor and the investor of the other country, or maybe the investor and the state, are you going to recognize my agreement, which will be in a different language? I don't understand Nepali, but does that mean that the Nepali agreement, like the agreement which is in Nepali language, is not of that standard, is not of that quality? So we need to first acknowledge and accept that yes, we will recognize your agreement, number one. But then what about the award? If an award comes in Nepal, are you going to enforce it in Pakistan? Sir, I will enforce, but if it is of that particular standard. So they thought about how to create that standard. So they came up with the idea of coming with the New York Convention, the most famous NYC, which was signed in 1958. There were like 35 countries who signed that, and they said, all right, these 35 countries, at least we agree that we need to have one singular setup of arbitration, and that arbitration award will be enforced within these signatory 36 countries. But if you want to enforce that award in these 36 countries, so at least the award coming out from these 36 countries should be of the same quality. And for that purposes, they said, right, so the basic element is the tribunal should use the same rules between these 35, 36 countries. So if a tribunal is sitting in England, Pakistan was one of the first signatories to the New York Convention. So if a tribunal is sitting in Pakistan, they should be using some X rules, and the same X rules should be used by the tribunal sitting in England, the tribunal sitting in France, the tribunal sitting in Germany, Italy, and so on and so forth, all the 36 countries. And they did that. Now they call it UNCITRAL model arbitration rules. Why we call it model? Because they said this is the model rules. And they took, you see, there was a conference in Vienna just 4 weeks ago, and lawyers from 36 countries sat down for 2 days, and they only talked about one clause. And you can now imagine how much time of these almost 38 countries they spent in developing the model arbitration rules, a neutral rules of how the tribunal should, take up the proceedings. But then the other problem came in, the other challenge was, since these are 36 countries, fine, you don't have to pass the that arbitration rules through your national assembly or your provincial assembly. It's just the matter of the party's choice and the tribunal to adopt, just like we adopt IBA guidelines. So, but if any problem goes on with regard to the tribunal, with regard to the proceeding, I was not given the equal opportunity. There was a material breach. There was procedural irregularity. Where do we go? Where we go to the national courts. So there were like 35 national courts of 35 different countries who signed. Now the other problem came in. So these arbitration rules, they were issued in 1976. But from 1976 until 1985, they realized that we now also need to give a harmonious arbitration act to all these 35 countries. But now there is a big problem, because it's not just that I'm going to pick that arbitration law and come down to my country and it will be, as perceived, what we say is pro pure, automatically enforced. It's not. We have to go and get it enforced we have to go and get it enacted as a matter of an act of the parliament. And it is a long process. Pakistan, who signed New York Convention in 1958, has still not enacted the model arbitration law in Pakistan, despite 75, 80 years, whatever the time is. But most of the countries, at the same time, from those 35 countries, the signatories started to add up. There are 172 signatories to it now. Out of 172, almost 80 countries have changed their law as per the UNCITRAL model law. And that model law is actually absolutely amazing, because if we try to develop that law, we are going to spend at least 70 years in order to reach to the same acumen. So, did you get the answer to your question? And Mr. Shastra? Shasta? I'm sorry, please pardon me with the pronunciation of the names. Nirajan, I can see your hand raised up.
Yeah, thank you. Thank you for your comprehensive questions, answer, and also the presentation. Can you tell us something about, in terms of value for money and time value of money, which ADR is more user friendly in your experience in case of domestic dispute resolution? This is my first question. And the
You are talking about which method is more appropriate.
Yeah, especially in institutional arbitration or ADR arbitration that you mentioned before.
Yep.
So
And question number
user friendly, I'm talking about the user friendly in terms of the value for money, in terms of the time saving.
Yep.
This is my first question. And second question, regarding, you categorize the arbitration in the regional international arbitration and also in international arbitration. So how you differentiate this arbitration from Asian Pacific to the
from
to the
national
Europe
to regional to international.
to the you mentioned it's Gora. So what kind of differentiate between you find during your experience in the international export?
Yes. So first question first. Your question was, it in terms of domestic matters, what should be the best one? So it's not about the domestic or international, because at the end of the day, the domestic parties are also looking for the same goal. They want to have an award that should sustain the testing by the court. In domestic cases, it's the national court, which is the Nepali court, and I hope it will go up until the Nepali Supreme Court. But now the question is, do the Nepali courts set aside the awards? Number one, yes, they do, and the ratio is quite big. It's quite a big ratio in terms of how things are working around. And then, which arbitration award will sustain the testing? So this is the other question: which arbitral award will sustain the testing? An award issued by Mr. X, or an award issued by Nepal International Arbitration Center? So the idea is, you don't have the institutional arbitration at the moment. We don't have it in Pakistan. But then if you are going to have ad hoc arbitrator, you are going to find the best, the most famous, somebody who is so skilled in his arbitration award writing. You are going to pick them up, because that award is the whole spirit, is the whole thing which we are fighting for. But then this is the good thing. Fine, the institute is going to look after the award, and that award will be so good, and it will be scrutinized, and it will be vetted, and it will be checked, that there will be no flaw, no mistake whatsoever will be left in the award, which is why the judges will find it so perfect that they are not going to intervene in the award, and it will sustain the testing. Fine. What is the problem? The problem is, institutional arbitration is very expensive. Ad hoc arbitration is 1/4 of the price of institutional arbitration. Where you are going to spend 1 lakh rupees for ad hoc arbitration and 4 lakh rupees on institutional arbitration. Do we have parties who want to spend money on that? But at the end of the day, parties have realized that it's not about 1 lakh or 4 lakh, because at the end of the day, spending even 4 lakh rupees is more, we are more happy because the award sustains the testing. And the beauty about arbitration is, you also get the costs. I'm not sure whether you have cost consequences in Nepal. We don't have cost consequences in Pakistan. But in England, where I practice as a barrister, there are cost consequences. You just can't you can't just go away for free by, bringing a claim and then you lose the claim. So the loser always pays the winner, whatever that cost is. So did you get the answer to this one? And then now moving on to this CIAB's role in strengthening arbitral institutions.
Yeah.
So the Chartered Institute is not an arbitration center. You can you can imagine us as the engine, as the powerhouse behind the arbitration institutes, behind the ADR centers. We train people to write, to produce an enforceable award. And this is what we do. We train people, we inject the knowledge in them, number one, and then we also inject the skill set in them. Skill set of what? Skill set of producing an enforceable award. Enforceable award is a proper terminology. It's not the enforceable in terms of the court, but the enforceable award means an arbitrator should be qualified enough to produce an enforceable award enforceable in the courts of England and Wales. And it's a skill. You need to learn that. So CIAB is a global training institution. We train people, we accredit people. And in arbitration, the Chartered Institute is the only Chartered Institute is the only institute that trains people to become arbitrators. It's the gold standard in the world. It's a qualification. It's a membership organization starting from ACIR to MCIR and fellowship. Fellowship is the key to enter into international arbitration. And it's not that I'm the chair of the Chartered Institute, which is why I'm professing the fellowship, but just go and visit the website of Singapore Arbitration Center or Akika of Australia or Hong Kong Arbitration Center. They require a mandatory requirement for every single member who wants to register as or to empanel as an arbitrator with these top arbitration centers, that they have to be a fellow of not any institute but the Chartered Institute of Arbitrators itself. And this is where that big money lies, where you go and if you sit as an arbitrator, you're charging $50,000, $60,000, $70,000. If you are working as a counsel before these tribunals, you are charging more than $300,000 per each case. So for countries like us, for countries like Nepal, Pakistan, India, Bangladesh, where the dollar versus the money element, it's really good to have, a thorough, proper income source flowing down from in terms of dollars. And that is only possible when you are able to extend yourself, extend your practice outside of Nepal, going into these places like Singapore, Dubai, and what do you want? Just the badge of fellowship. You will be distinct. People will give you that respect that you can produce an enforceable what, and then you should be hired. And institutional collaboration. In Chartered Institute have got no competition whatsoever. Wherever you'll find top quality arbitrators, they will be the members of Chartered Institute of Arbitrators. And we do joint programs with ADR Center, just like we are doing today with NIAC. I'm more than happy, truly honored that this is how we build that capacity among people. And then CIAB accreditation, Singapore Arbitration Center, AIAC, HKIAC, you have to have that fellowship with you in order to be there. Why ADR centers trust CIAB empanelment, membership for empanelment? Because you undergo a rigorous training. We train you to produce that enforceable award, and that award is actually really, that award should sustain the testing. And if you have not undergone a training, if you don't know what an award is, and you're trying to learn by experience, I don't challenge that. We all learn from experience, but you need to first learn properly what an award is, how is it structured, what is the operative part, how you start, how you address, how you deal with every single issue. And that is really, really, really important. So we have got people in 150 plus jurisdictions, 21,000 plus members, and this is how things are working around. So I'm now open up with the questions. If there is anything that you think I have not emphasized or something which is not clear enough, I'm here for the questions now. Mr. Madrika, how much time do we have now?
Yeah, thank you, Sheraz, for your
Please.
for your for your clarification.
So any questions from the floor?
Other friends, do you have any questions? Dr. Mukti? I think you deal, Sheraz, Mr. Sheraz, you deal perfectly. I would like to offer my sincere thanks on behalf of all my fellow participants. Hariji,
Ajay sir,
you have something to ask with Mr. Sheraz?
I don't have, sir. Thank you so much.
Okay. Okay, thank you so much, Mr. Sheraz. Thank you so much indeed. We
No,
are
not at all.
really
Yes, Miss
obliged.
Janish.
Yeah, you can ask.
You are on mute if you're trying to say something.
You can write there, please. Any questions?
Ma'am, please try again for unmute.
Yes, I did, but I think it was not happening from the other end. My question is about the CIRB training. So what's the
Yeah.
timeline for that?
Oh, very good.
So for but I don't know, for some reason Nepal, the Kathmandu is really getting close to my heart, and I offered myself that Pakistan branch is willing to support people of Nepal to set up their own branch. And for
Yeah.
that, we recently got a chapter, a Nepal chapter, approved by the Chartered Institute of Arbitrators. And I think for people who are lawyers, they can straight away get the associate membership. You can contact me directly. I can. I'll paste my LinkedIn details here. Just feel free to contact me whenever you want. I'll connect you to the branch. I'll share the numbers of the branch as well. But for associate membership, going on to the to MCIR, what we call is the first training. That first training is about the entire international arbitration principles. What we call it the practice, rules, and procedures of international arbitration. It's a class which is designed for 24 hours. 24 hours split it in three sessions, 4 hours, 4 hours each. It's one tutorial, Saturday, Sunday, then 3 weeks of gap, 4 hour, 4 hour tutorial two, then 3 weeks of gap, and then 4 hour, 4 hour tutorial. So like 24 hours in total. Um, in Pakistan, we charge 2,12,000 rupees, which is like your around 1 lakh rupees. And we have not added any single penny on tops of that. And whatever the Pakistan branch rates have been given by the HQ, that has been passed on to the Nepali branch. We are about to start a one cohort exclusively for the people of Nepal. And Mr. Matrika will be leading from NIAC. If you are willing to be part of that cohort, I think we have already got 15 people. We had to have 15 people, but please register your interest with him, and I'm more than happy to add you up in one of the cohorts. And
Thank you so much.
once you get this module one, you become MCIR. Lawyers get module 2 exempted, that is law of obligation, and then module 3 is about award writing. So then after module 3 you become fellow of the institute.
Great. Yes. Thank you.
Yeah. Pahariji, we will
Yes.
talk about tomorrow morning also
Sure.
in certain time. Then anybody? Okay, no questions. That's a big question.
Sir, this is what I used to say. Either like they understood everything or they understood nothing. I hope they're able to that. But it was a pleasure. Thank you so very much for having me here. And in whatever terms, in whatever capacity, I can mentor people. if you need any sort of help in career development, anything, please feel free to come reach out to me. I'm more than delighted. I'm always happy to respond.
Thank you so much, dear friend Sheraji.
Sure.
We really love you, and
Yeah.
we hope you will be in Nepal time and again. We
Yeah.
hope so.
Yes,
Please do
inshallah. Very soon.
care of us. Okay?
Yep.
Thank
Yep.
you so much. Good
Yeah.
evening, everyone.
Yeah.
Namaste and bye
Thank
bye.
you. Thank you. Namaste.
Thank you.
Namaste.
Good night to
Namaste.
all.